What's up, good people? We're right back at it. This video is going to be called the Lex Mercatoria, also known as the Law Merchant. Now, in the last video that I did, All Roads Lead to Rome, we gave you a hardcore introduction to our financial and our law systems and the origins of. This one, we're going to go more into what the law merchant is and all the different aspects of the law merchant or the Lex Mercatoria. Now, this excerpt that I'll be reading from is called Introduction to the Law Merchant, and this is by Byron Beers, and the link to this read will be in the description, and I highly suggest that you download it and check it out, follow along with this presentation, because this is very important information, as is all information, especially this, because if you're floating around blind to the game, you can't play the game effectively. So that's why I feel that it's very important that this information be spread. So please be sure to share the information, engage with the content, because we need to get this out here. There's no reason why everyone should be suffering, or anyone should be suffering the effects of the game, because you're in it whether you know it or whether you like it or not. So we're going to get started. The law merchant is, in fact, an independent parallel system of law like equity or admiralty. The King's Court administered not local custom, nor even custom of the realm, but rules applied in commercial causes in all countries. The negotiable instruments law, however, expressly adopts the law merchant, not the rules of the common law, as to matters not covered therein, and this court is required to take judicial notice thereof. Right, and that is case law from Bank of Conway versus Theory 200 N.W. 505 from 1924. All right. To be free with liberty and not becoming someone's slave by not being subject to the will of another requires knowledge and understanding of the methods of deception. Okay, we're going to read some excerpts from the Bible also. James chapter 1 verse 25. But who looks into the perfect law, the law of liberty, and perseveres, being no hearer that forgets, but a doer that acts, he shall be blessed in his doing. All right, and then 1 Corinthians chapter 7 verse 23. Be not ye the servants of men. We were never meant to be men's servants or have people above us in a hierarchy of law. That's not what life is about, or that's not what my life is about. And if you believe in ultimate divine freedom, then you'll find this value. All right, Galatians chapter 5 verse 1. Stand fast, therefore, in the liberty with which Christ hath made us free, and be not entangled again with the yoke of bondage. In the system that we're currently under here in the United States, and in every system in every country, is the biggest passive aggressive system of slavery that I've ever been privy to discover. Right, so we're going to get to the introduction now. You can go and read a lot of those other Bible inserts, but we're going to jump into it because I want to keep this pretty short and sweet. This is a 57-page read. We're just going to jump into the meat of it, and from there, you do your own due diligence and take with it what you will, because, like I said, this is probably the most important study that you're going to come across when it comes to understanding the system. Not only does the Bible address liberty and the importance of avoiding slavery in all its aspects, but America's early statesmen advised and warned the American people to remain free, proclaim liberty throughout the land, and not to become servants or slaves of others. You might think it will be relatively easy to remain free and out of the yoke of bondage If you are unaware of the various cunning and deceptive methods used by certain associations or merchants of earth, it may surprise you how sophisticated is the practice of deception. While the Bible served as a foundation of the common law of the American people initially, today the rules and customs of the merchants, known as the law merchant, reign supreme. This writing will look at some of the history and practices of the global merchants. How can foreigners use the principles of law merchant to create statutes, regulations, and codes, thereby becoming the major source of law and justice? The reason many believe that America has a real problem with this current form of law and the manner in which courts operate is because the law merchant is designed for purposes of revenue and control, creating various degrees of chaos. It is not for a purpose of harmony, peace, honor, and moral qualities. If one wanted to reap the fruits of the energy of a people or obtain legal or equitable title to other natural resources within a country, how would one go about implementing such a plan? If you can get a security interest, which could lead to a valid title on the nations of the world, you can in effect control national governments, their citizens, and their property, as well as other national assets or resources. If you chose some valuable resources that you would like to own or control within a particular country, rather than a military conquest, you could make a loan to the head of state for a project that will be deemed beneficial to the people. And this is where the statement, "the pen is mightier than the sword," comes from, because there's multiple ways of enslaving people without, lifting one sword, and that's by lifting a finger and using the pen to get them involved in a contract of debt bondage. All right, now carrying on. Constructing oil wells, building a dam for the production of electricity, a canal, or other similar project would suffice. This is not to say that getting a nation involved in a war is still the biggest debt creator for which a country may seek the major financial lenders. The object is to get the president or the appropriate public officials to agree to borrow money. Of course, those state officials who assist in getting a loan accomplished will be the recipients of the financial rewards. An important element in the plan is assuring the country will be unable to repay the loan. Okay, I'm gonna read that part again. An important element in the plan is assuring the country will be unable to repay the loan. And I've used this example before when I've tried to explain people what the currency of the United States represents, and it represents a tax. And we know that to be a debt currency because if you take the first $100,000 that's ever loaned into existence, okay, now think about what I'm saying here. This is the first $100,000 that's ever created, okay? Now, say there's a 10% interest on this $100,000 that's the first ever loan into existence. So the payback amount is $110,000, right? Okay, so if this is the first ever $100,000 loan into existence, where are you going to get the other $10,000 to pay back the interest of this loan? Okay, you're not going to be able to get it. It has to be loaned into existence. That other $10,000 also has to be loaned into existence, since there's only $100,000 in circulation. And that's the whole point of this study. And the security interest in property with a loan that cannot be repaid. An important element in the plan is assuring the country will be unable to repay the loan. Whatever resources within the country are used as collateral or surety for the original loan would then be under the control of the creditor. The creditor would acquire a security interest in a few and possible all of the revenue producing resources, as well as other things of value within the control of the debtor national government. Other elements that need to be considered in this plan are that the country would need to be organized as a nation with the national government, which is deemed to be the sovereign head. I'm gonna pause for a second because it's getting kind of noisy in here. All right, we're right back at it. This will be beneficial since the national government has authority over all persons and property within the nation. Also, the subjects or citizens of a national government could be considered taxpayers, which represent another source of revenue for repayment of the loan and as collateral or surety in the event that the national government defaults on its obligation. Just like other collateral, the creditor of a national government would have a security interest in the subjects or citizens of the national government. Upon default, either through bankruptcy, insolvency, or otherwise, the merchant lender or construction company could control legislation, executive and judicial or administrative acts or actions with respect to all persons and property of the debtor government, and continue to receive revenue from all sources with respect to such persons and property. In essence, the citizenry or the subjects, invaluable resources of the nation, could be under the control of the merchants who hold a security interest or have obtained whatever rights and title the debtor government possessed. Maybe you think this is an unbelievable scenario. John Perkins is a man who worked for the major merchants of the earth. He wrote a book recently entitled Confessions of an Economic Hitman, wherein he describes his work as illustrated above in a scenario for getting a country into debt and controlling its resources because it will be unable to repay the loan. If the country's president refuses the loan arrangement, it is then necessary to replace the president or person who becomes an obstacle to the fulfillment of the plan by whatever means necessary. If you understand modern banking practices, fractional reserve banking, and paper currencies, you realize the creditor banking merchants may not have actually used their money in making a loan to the head of state of some nation. I'm going to read that again. If you understand modern banking practices, fractional reserve banking, and paper currencies, you realize the creditor banking merchants may not have actually used their money in making a loan to the head of state of some nation. Depositing and marketing the promissory note or other evidence of indebtedness will make that commercial instrument the source of funding the loan. That is to say, it is possible a paper that appears to be evidence of indebtedness is also at the same time an asset to create funds in international markets. To summarize this scheme, one could say that obtaining ownership, control, or security interest in the resources of a nation, the merchant bankers or contractors could obtain a status or position superior to the debtor government of a nation. In this position, they control and regulate the activities within the nation, like a shadow government or invincible government, providing written legislation for the existing legislative bodies to adopt or enact on their behalf. This legislation would be based upon the Lex Mercatoria, or the law merchant. One might say the great merchants are developing Babylon-like cities and nations around the globe. All right, next we're going to jump into defining the Lex Mercatoria, or the law merchant. The law merchant is often described as the body of rules applied to commercial transactions derived from the practices of international merchants and traders. However, the scenario depicted above and other historical writings show that the customs or rules of the merchants is likely to be integrated into the general law or jurisprudence of the debtor nation, or as the result of their influence, financial or otherwise. Law merchant, as defined by Bouvier's Dictionary of 1856. A system of customs acknowledged and taken notice of by all commercial nations. And those customs constitute a part of the general law of the land. And being a part of that law, their existence cannot be proved by witnesses, but the judges are bound to take notice of them ex officio. All right, now American People's Encyclopedia describes the law merchant as a body of rules for regulating the relations of merchants engaged in international trade. It was founded upon the customs of merchants, which were sometimes embodied in written rules such as the Laws of Oleron, a code of maritime law published in the 12th century. Law merchant originated in Western Europe during the Middle Ages and was subsequently recognized by the principal commercial nations. Although it was at first administered by separate tribunals in the principal trading cities, it eventually became part of the domestic law of the countries in which it flourished, including the United States. Law merchant was the basis of the modern system of admiralty law and the laws of negotiable paper and of sales. See maritime law. So if you've ever been to court and you've expressed your will to challenge the jurisdiction of the court and to know the nature and the cause of the action, they will never ever disclose to you, and I know this by firsthand knowledge, they will never disclose to you that you're in an administrative admiralty maritime tribunal. And it's a combination of a lot of those things, as well as common law and equity, but they use different aspects of those jurisdictions at different times in the case to get jurisdiction over you and to keep control over whatever commercial transaction is taking place. Because as you'll find in the Code of Federal Regulations, I believe it's 27 CFR 7211, it may have been moved by now, but all crimes are commercial. They're all commercial transactions. So all the statutes and codes and regulations, or like say the Ohio's statutes or the Ohio Revised Codes, are all commercial. They're all commercial items. It's like a commercial product. Okay, so once you get hit with, say, speeding, that is considered a commercial product of whatever jurisdiction, local, state, or otherwise, that produced that statute. The law merchant went from being principles and rules applied to the international merchants and traders to being incorporated into the general laws of a country. Its effect, the law merchant, merchants being the great men of the earth, took control of admiralty and common law of England, which was then adopted into the laws of the states and the United States. All right, commercial law. The laws that govern business transactions. Formal documents and other evidences of regularized trade practices were known in Egypt and Babylonia. In many parts of the ancient world, foreign merchants, through treaty arrangements or other arrangements, were allowed to regulate their affairs and adjudicate their own disputes without interference from local authorities. They tended to settle in special sections of commercial cities where they might follow their own religions, laws, and customs. Roman law incorporated features of the already developed commercial law, which, however, was no longer handled separately in special courts, but was treated simply as part of the whole legal system. The barbarian invasions of Europe caused such social disruption that it was not until the late Middle Ages that long-range commerce again became possible in Europe, and merchants were once more able to determine the rules and regulations under which they could safely operate. In the cities of northern Italy and South France, the merchant class frequently dominated the state and could enact the needed rules and legislation. In other parts of Europe, associations of merchants bought protection from the powerful lords or kings. The state, who granted them safe conduct and permitted them to conduct affairs and to establish regulations and methods of enforcement. And then in the parentheses it says, see the Hanseatic League. Both classes of merchants established special courts where summary judgment was granted, with little regard for the technicalities or procedure in doctrining the regular courts, and without the necessity for lawyers. The term law merchant was applied to the substantive principles, so it's a part of substantive law and substantive due process. Was applied to substantive principles that eventually emerged from this quasi-judicial activity. And if you know and understand that word quasi-judicial, if you hear quasi-criminal, quasi-judicial, quasi-contract, quasi means of likeness, but not the same. It may be similar, but it doesn't have the same effect. Okay, so quasi-judicial means similar to judicial, but it's not actually judicial. And it's quasi because it's actually administrative instead of judicial. Law merchant, consisting of certain principles of equity and usages of trade which general convenience and a common sense of justice have established to regulate the dealings of merchants and mariners in all the commercial countries of the civilized world. The basis of the jurisprudence regulating bills of exchange and promissory notes, particularly the negotiability of such instruments and the right and liabilities of persons becoming parties to the instrument. The Lex Mercatoria was not, like common law, the custom of a place or a territory. It was the recognized customs of merchants and traders, the merchant class, and the controversies of its members arising out of the commercial transactions were not subject to the common law. I'm going to repeat that again. The merchant class and the controversies of its members arising out of commercial transactions were not subject to the common law. Okay, so this is completely out of the realm of the common law. During the 16th century, the Admiralty Court declared the principles of the law merchant. The later common law judges encroached upon the field of admiralty over commercial transactions. Thus, the law merchant gradually became a part of the legal system of England. And that's from Ballantyne's Law Dictionary, 3rd edition from 1969. First, it should be said that the rules of commercial law or law merchants are not the problem. It is the deceptions and illusions, the trickery, that cause enormous problems and disharmony whenever the great merchants apply their trade. And that is evident when you go into these courts or you go into a contract with any of these corporations and they move to take you into a court to enforce whatever agreement that you may have defaulted on, and you can't get a clear description of the nature and cause of the case because they have taken silent judicial notice to never tell you that it's an Admiralty Maritime contract or an international contract, because that international contract has to be on the record for them to have jurisdiction over you. And a lot of times that is their fatal flaw because they never do. But if you voluntarily go into the court in a general capacity as opposed to a special capacity, then you waive challenging that jurisdiction. But this is the trickery and the deception of these courts because the attorneys that you may hire are going to subject you to the jurisdiction of the court, and they're never going to tell you this. In the foregoing, we find that the principles of the law merchant go back to Babylon. The major merchants desired to be exempt from the laws of a country or place wherein they might conduct business. They sought to have their rules and remedies handled in special courts. The procedure of these special courts would later become integrated into the regular courts, making the regular courts irregular. The regular judicial courts might have been given a new name, but most people will be unaware of the change. The merchants could establish their own rules and regulations, which eventually might become part of the general laws of a country and be enacted by a legislature that would benefit the merchants. The merchants might make payments to the political officials in exchange for the passage of legislation and for the protection of their trade or benefits. While we have seen it reported that the law merchant, rather than be separate and special, become part of the legal system, it may also be appropriate to say that the law merchant became the legal system. And that's exactly what's happening. We shall later see the deceptions involving banking and lending and obtaining security or beneficial interest in assets through the illusion of being a creditor. And that's exactly what it is. It's an illusion. Because a legal fiction, in which we'll see later on, can never extend you credit. They cannot be a creator of credit because they're a legal fiction. They only exist on paper. So the substance, which is the American people and the energy of the American people, is actually where the credit originates. In the following quote, the author gives the term Lex Mercatoria a broader definition than merchant law. The Lex Mercatoria would seem to be in part based on Roman law, in part maritime custom, and in part law of the medieval European fairs, and to be great extent upon the last. Here we have coupled together Roman law, which is the law saying the state is God, maritime law, which is international law of war and commerce, and merchant law, which is the present day law of the national and international banking. The law of negotiable instruments, with a few exceptions, is founded entirely upon the customs of merchants, known today as the Uniform Commercial Code. And the Uniform Commercial Code has been adopted into every state of the Union since 1965, I believe, but it is encoded in every state. Okay, so if you search, say, UCC 3-108, and you put in whatever your state is, then it'll pull up the revised code of that Uniform Commercial Code section in your state. Right, from the Handbook of Roman Law by Max Radin, Professor of Law, University of California, West Publishing, we find the three categories listed under law merchant are 1, negotiable instruments, 2, bankruptcy, 3, insurance. Okay, and that's the whole crux of this system, because we're all operating in a paper empire of negotiable instruments. We are operating in a bankruptcy, and we've been operating in that bankruptcy since 1933, and the New Deal that was installed along with the several emergency banking acts that have taken place after that have to be, which covers those negotiable instruments, all having to be insured. Another way of looking at those categories would be that the law merchant deals with creditors and debtors, with liability, with security or things of value that can be used as collateral by debtors for the security of a creditor, and with protection from financial loss. In the American People's Encyclopedia, Grolier Incorporated, 1968, we find commercial law embraces principal and agent, bills and notes, insurance carriers, surety and guarantee, and other titles. For origins of commercial law, see law merchant. All right, so we're going to skip down, but you can take a look at this part 3, law merchant, commercial law, substantive law, maritime law, admiralty law, administrative law, and positive law. That's a very important part of this read. I'm just going to scroll down here, and we're going to start here at commercial law on page 13. A phrase used to designate a whole body of substantive jurisprudence. Example given, Uniform Commercial Code, the Truth in Lending Act. Applicable to the rights, intercourse, and relations of persons engaged in commerce, trade, or mercantile pursuits. See UCC, and that's from Black's Law Dictionary, 6th edition. And I'm going to keep coming down here, and we're going to start here on page 15, second paragraph. That slavery is a relation founded in force, not in right existing, where it does by force of positive law and not recognized as founded in natural right, is intimated by the definition of slavery in civil law. The slavery is contrary to the principles of natural right and to the great law of love. That is, slavery is founded on injustice and fraud and can be supported only by the provisions of positive law or positions which it is not necessary here to prove. The very idea of slavery implies that the slave is the one who is in subjection to the will of another. And that's exactly what slavery is. If you look up the definition, it is being subject to the will of another against the will of your own. Earlier quote said that substantive law is the positive law of rights and duties, and substantive law is commercial law. All crimes are commercial. Remember, I said that earlier. But that statement does not give you sufficient information to understand its relevancy. The law merchant or commercial law deals much with creditors and debtors, but a major invention of the merchants was securities, or having security interest in things to which they do not possess nor own. Another important invention of the merchants was imprisonment for debtors, which is why a community or nation of subjects or quasi-slaves is important. Okay, now I'm going to jump back up here and we're going to look at, it says the law merchant or commercial law deals much with creditors and debtors, but the major invention, right, was securities, or having a security interest in things they do not own or possess. But in order for that security interest to attach, there must be proof of value provided to, the borrower or the debtor. And without that proof that the value was given to the debtor or the borrower, that security interest cannot attach. And it's very important that you keep that in mind. All right. Rather say that all crimes are commercial, the picture would be more clear if we said all crimes pertain to slaves. If we understood that all crimes involve those who have a commercial obligation to another, and according to the general law merchant theory, the property of a debtor and the body of a debtor is security for his debt, then you might see the slave relationship. Before you get the concept that the body of a debtor is security for his debt, which is why prisons are overflowing, you need the potential debtor to be a slave with respect to the superior political authority, even though the same individual appears to be free with respect to all others and may even be unaware he has a slave relationship. I need to direct you to the treatise A Society of Slaves and Freedmen for more comprehensive discussion on this topic. And I believe that's another one of his, Byron Beer's treatise, The Society of Slaves and Freedmen. And in this, once you download this treatise by Byron Beers, at the beginning, you'll see a whole list of his other treatises that he's written. And all of these are available absolutely free on the internet. All right, moving along. Slaves are commercial property or commercial persons. The law merchant is designed to operate in a society of quasi-slaves known as freedmen, or an English feudal system known as villains. For merchants to reap wealth from their securities, the national resources must be out in the marketplace, producing more and more wealth and applying for more loans. So the more loans that you apply for, the more securities are produced and they're traded on the New York Stock Exchange and all these other exchanges. Revenue can then be extracted from fees, taxes, licenses, permits, registrations, and inflation. Recessions, monetary cycles, statute penalties, insurance, and other bonds can be implemented to cover down time while the producers are incarcerated. The producers must be laden with payments on loans when no actual loans occurred in the merchant-controlled banking system, etc. The principles or rules of the law merchant are generally known by the proceedings of the medieval fairs conducted by the great merchants. Interestingly, these fairs in England were conducted in places where the inhabitants were villains. Villains owe obligation to a master in a slave relationship, but appear to be free to all others. All right, I refer to villains as quasi-slaves, and quasi-slave is a term used in Black's 7th edition in defining emancipation. To free a slave called manumission. The emancipation of a slave is merely a transfer, conveyance, or purchase. The emancipated slave was designated as a United States citizen that was subject to the superior political power of the government of the United States in its national character. The emancipated slave just took on a new master. So, Abraham Lincoln did not free any slave, especially so-called black slaves, under that Emancipation Proclamation. The United States citizen has the characteristics of a villain, i.e., a quasi-slave that appears to be free, but is still a slave to that superior political authority from which it receives substantive duties, rights, and obligations that are enforced according to that adjective or the procedural law. The quasi-slave is likewise subject to the political or special courts functioning under the so-called political branch of national government. Congress called them freedmen, which is the same as villain or quasi-slave. All right, now if you go into the definition, if you go into the YouTube playlist of What's the Word and look up United States business or U.S. citizen, you'll see that it's a United States business. So United States citizen is equivalent to a United States business, which is formed under the rules and the jurisdiction of the United States. And then we'll go deeper into Article 4 of the Constitution. You'll see that it's classified as other property of the United States. A foundational element for the operation of the law merchant, substantive law, positive law, and administrative law, etc., is slavery. But deception is most important because the law must not appear to be based upon slavery. With that in mind, while great merchants operate behind the scenes with their security interests and control over national resources, it must appear that the ordinary de jure system of the country is continuing even though changes are occurring. And the original de jure system of the United States was dissolved. It was dissolved back in 1933 through the bankruptcy and the New Deal. And so the United States de jure government has only existed in name only ever since. The government becomes trustees for the great merchants overseeing or administering the assets or affairs of the security holders. This is known as administrative law, operated in large part by a level of trustees known as administrative agencies. And so you'll understand if you go to any court website, any court of common pleas, you'll see that it's an administrative court, and they'll have that court administrator position in every court. In every jurisdiction, you'll have that administrative agency. For some time now, the sheer amount of law, the substantive rules that regulate private conduct and direct the operation of government made by these agencies has far outnumbered the lawmaking engaged in Congress through the traditional process. Rule is an agency statement designed to implement, interpret, or prescribe law or policy. When agencies are authorized to prescribe law through substantive rulemaking, the administrator's regulation is not only due deference, but it is accorded legislative effect and grants rights to those and grants rights to and impose obligations on the public. In sum, they have the force of law. Okay, see Enns v. Shada, 462 U.S. 919, 984, 1983. The constitutional independence of the administrative tribunal presupposes that it will perform the functions of completing unfinished law. The rise of administrative bodies probably has been the most significant legal trend of the last century, and perhaps more values today are affected by their decisions than those of all courts' review of administrative decisions apart. Administrative agencies have been called quasi-legislative, quasi-executive, or quasi-judicial, as the occasion required, in order to validate their functions within the separation of powers scheme of the Constitution. The mere retreat to the qualifying quasi is implicit with the confession that all recognized classifications have been broken down. And that's the Federal Trade Commission versus Breweroy Co. 343 U.S. 470 487 of 1952. All right. Do you get the impression that someone has taken control of the regular de jure government and an outside force is at work placing people in positions as heads of administrative agencies that are creating legislation and regulations through substantive rulemaking or commercial law or the law merchant, and who grants rights to and impose obligations on the public? Also, the true constitutional judicial power courts have little to do in this system. They merely review substantive or procedural law concerning these law merchant administrative affairs on the rare occasions that the judicial power is actually used. All right, so we're going to jump into the Administrative Procedures Act, which is a very important act for you to study as well. The Administrative Procedures Act 5, United States Code 551, Part 4 provides that a rule is an agency statement designed to implement, interpret, or prescribe law or policy. When agencies are authorized to prescribe law through substantive rulemaking, the administrator's regulation is not only due deference, but is accorded legislative effect. Administrative law, the law governing the organization and operation of the executive branch of government, including independent agencies, and the relations of the executive with the legislature, the judiciary, and the public. Administrative law includes the statutes endowing agencies with powers in establishing rules of substantive law relating to those powers. And that's from Black's Law Dictionary, 7th edition. All right, now I'm going to read this next few parts right here, and then we're going to end this presentation. The legislature could not, by adopting the Code of Criminal Procedure, change the substantive law of the state because no such authority was conferred by the Constitution. In the Rodesta case, we pointed out the difference between substantive and procedural law and said that as relates to crimes, substantive law is that which declares that what acts are crimes and prescribes the punishment for committing them. Procedural law is that which provides or regulates the steps by which one who violates a criminal statute is punished. A statute relating to criminal procedure is a law, but not substantive law. The term law includes substantive law and adjective law, or law of procedure. Substantive law, speaking broadly, is that which creates duties, rights, and obligations. It orders and permits and forbids and announces rewards and punishments. As relates to crimes and offenses, it declares what acts are crimes and prescribes the punishment for committing them. Adjective or procedure law is that which provides a method of enforcing and protecting such duties, rights, and obligations as are created by substantive laws. As relates to criminal prosecutions, procedure law includes within its meaning whatever is embraced by the three technical terms pleading, evidence, and practice. And that is provided in the case State State v. Elmore, 155 SO 896, 897, 898, 1934. All right. In those words, do you see the statements as addressing free people, or do they sound like a system of commands or prohibitions for slaves? Do free people knowingly authorize a servant legislative body to adopt a code that grants them their rights and creates obligations? This is the law merchant and how the merchants control nations. We're going to end it right here. This is a very valuable read. And I highly suggest you take this, study it. I've read this at least 10 times. Come back, or read it, take notes on it, study it if you really want to know and understand this system and how it operates, and how you can actually become the security interest holder in all of your contracts and your affairs, which is very important that you do. I highly suggest that you take this serious and conduct your own due diligence and put the power back in your hands. All right. Y'all have a good one, and I'll see y'all in the next video. Y'all be the best.